The next responsibility of the Public Information Officer, keeping the spirits of the Right to Information Act, is to decide whether the information sought can be provided or not. I think this is a very important and a crucial decision that a Public Information Officer must undertake. Now, he must read the application, he must scrutinize the application, and he must check whether what is sought can be provided or not. Because under the Right to Information Act, the prima facie decision of providing the information squarely lies on the Public Information Officer, because he is the starting point of the implementation, enforcement, interpretation, and application of the Right to Information Act. So, unless the PIO knows whether the said information that is asked can be given or cannot be given, if he cannot make that decision, I think the whole RTI regime gets into a difficult situation, and it collapses, and it will just end up in litigation and so on and so forth, and it will probably escalate the whole matter. And hence, look at the role of the PIO. It's so crucial and important. If we are seeking redressal of grievances, if we are saying that the RTI should end and stop with the PIO, then in that sense, the ability of the PIO to make this decision becomes so very critical and crucial as well. And it is his attitude that will determine whether a complaint will be filed before Information Commission or not. Right? So, the PIO will decide whether the information sought can be provided. He has to make this. If it can be provided, then he should start collecting the information, from whom, where, how much. If not, he immediately takes that decision and probably has to communicate it to the citizen that this information cannot be provided. And please note, if he comes to this decision that the information cannot be provided, he has to find out under which provision of law he is going to exercise that decision of not providing the information. For example, the exempted informations are defined under Section 8. So he makes the decision, he quotes the section, and then he sends the communication as the case may be, as required to the citizen as well. So this decision of to give or not to give is completely on the Public Information Officer. This next responsibility, or the sixth responsibility that a PIO has, is to look at accessing the office or the department or the offices concerned where the information is. So this is like he has to scout for the information, because remember, the Public Information Officer is not the custodian of all information, right? He is not a storekeeper. He is not a record keeper. He is not an archive officer. So the information that is sought may be available in his organization, but in which department it is, in which office it is, in which desk it is, or with which officer it is, I think he'll have to have that kind of hands-on information and experience to know that who will have this information, so that he can call for the same and assess what should be the reply that has to be given to the citizen. So this is where he gets into a role of coordination, monitoring, supervision, and also collecting the said information that is necessary and required to be provided to the citizen under the Right to Information Act. Following the responsibility of point number 6 comes point number 7, where he says that, look, I need the assistance of officers in the organization. It could be a person who is doing the photocopying, it could be a person who is taking printouts, it could be people who are managing computers and systems so that the information can be known where it is and how it is. He must seek the assistance of the procurement division to have contracts. He may require the assistance of his own boss or a senior with whom the information is available. So I think despite seniority and juniority, everybody in the organization is duty bound to assist the Public Information Officer in his functioning under the Right to Information Act. That is something that he can definitely seek, and please know, seeking assistance of any officer in the organization is a statutory right to the PIO. And I'll explain this when we discuss Section 5.4. So the law provides, I must say, empowers the Public Information Officer to seek the assistance. And please note, that cannot be denied. So the PIO has been empowered adequately enough to fulfill his functions under the Right to Information Act. Point number 8. It is the responsibility of the Public Information Officer to provide the information within the specified time under Section 7. So, the PIO cannot take his sweet time in providing the said information. Right? The law stipulates a time frame. We will discuss this, right, from 30 days to 45 days within which he has to process the application and provide the information. And please note the information should reach the citizen within those number of days is what the law prescribes. So that is what the law clearly states. So he must provide the information within the specified time. If not, he is liable for penalty. The function or the responsibility of number 9 on the public information officer is that if the information is sought that belongs to another public authority. What happens in applications are the citizens have the tendency of seeking information from more than one public authority. Right, so the first information may be concerning the current public authority. The second information may be, somewhere connected to some other public authority. So, citizens very often they have no clue or idea where this information is. So they may misdirect the application, and hence this misdirection of application by citizens, it is the duty of the public information officer to check to which public authority is the information sought belongs to. And if it belongs to some other public authority, it is the duty, kindly note, of the PIO under section 6(3) to transfer the application to the concerned public authority. So we will also deal with this transfer provision in some detail, but just to tell you what a PIO must do. So what is concerning him, he has to process. What is not concerning him, probably the public information officer has a duty to transfer. The responsibility number 10 on a public information officer is this, that he may allow partial access to the information. Now, this is also critical in terms of the judgment that the PIO has to make, because if he comes to this conclusion that the information largely pertains to an exempted information, he may deny that information. However, please note, the PIO has to apply his mind. He has to take a reasoned decision. He has to look at equity, justice. He has to look at ensuring the right, protecting the right. And when he does that, it would be very relevant to understand that sometimes there could be some information that can be allowed. This is what is known as the partial access to information that the PIO is supposed to do or take. And when partial access is allowed and the PIO makes such a decision, he has to give notice to the application or the applicant, as the case may be, informing that, look, the record or the information that you have sought is unfortunately exempted. However, a part of the same is permissible and can be provided for, and hence the doctrine of severability is going to be applied to those records and documents. And what is accessible, I'm going to share with you. What is not accessible, is being denied under the provisions of the law. This kind of decision-making capacity must be there in the PIO, and he must know that partial access is something that is provided under the Right to Information Act, and he is supposed to facilitate even a partial access if the case is so and can be done under the Right to Information Act. Kindly note, partial access of information can be vis-a-vis even one page of a document where the public information officer decides to block a paragraph and probably give the rest of the page and the information in that page through a photocopy. Right? He can block a file noting if the case is so sensitive or the noting is so sensitive that he thinks is to be exempted under section 8. So all of these is brought under the issue of partial access. Right? So he has to apply his mind, and he has to make a delicate balance between the right to information of the citizen to seek the information, access the information, know the information, as well as balance the interest of the public authority and the concerned officer in terms of confidentiality, trade secret, threat to life and liberty, and so on and so forth. So that kind of delicate balance is what the PIO is supposed to do under the Right to Information Act. Responsibility number 11 is that the PIO must reply finally to the application in whichever sense, either in the positive sense or the negative sense. The reply of the PIO is very, very important. And hence, there are certain guidelines on what the reply must contain. First and the foremost, the PIO's reply must contain the reasons for the decision. Either positive or affirmative, he has to give reasons. Secondly, if he has any finding on the material, then he must disclose those findings as well. Right? The finding could be did I take the transfer, did I transfer it, and this is what I have done in terms of the transfer. So he will have to probably take those material findings and probably communicate the same. Very important, he must give the name and designation of the person giving the information. He must give his name and designation, and he must give the name and designation of the concerned individual caseworker who has provided the said information, right? Because finally, please note, there are multiple allegations that the information provided is inaccurate, inadequate, false, and deliberately misleading. Now, you will notice that the public information officer is not always the person who is expert in the information that is sought, right? And if he has sought the assistance of another officer to providing that said information, if that officer deliberately gives misleading, false, inaccurate information, then the penalty is going to be on the PIO. And hence it should be very clear on the part of the PIO. He must say, look, this is the officer who had the information and he has provided the same, right? So that is very clear about who is or was at fault, so that tomorrow the penalty is not put on the public information officer. Very important that he should communicate the details of the fee that the applicant has to pay. Please note, we have two kinds of fee structures under the Right to Information Act. First is the application fee, which I have already mentioned is 10 rupees per page. And the second fee is also very important. It is called the information fee. So finally, after processing the application, the PIO comes to know that, say, the information sought is amounting to 100 pages. And hence 100 pages, and the rules very clearly say 2 rupees per page. That is 200 rupees is something that the public information officer has to communicate to the citizen as the information fee that has to be paid and deposited. Once the information fee is paid and deposited, then the information is generally supplied to the citizen under the Right to Information Act. So that is the communication that the public information officer ought to do. The last responsibility, responsibility number 12. Please note, these are not exhaustive, but these are just indicative responsibilities that the PIO has. However, the last responsibility that the PIO may have is to the third parties. Generally, the information sought belongs to a third party. And please note, that is something that is covered under Section 11 of the Right to Information Act. Who is a third party? It could be a contractor, it could be any other individual whose information exists in the government organization. It could be a private individual or a private authority as well, whose information is available or is there in a government organization and hence is a designated third party. In those circumstances, it is the duty of the public information officer to seek objections from the third party. And so he has to write to the third party and he has to state that, look, somebody is seeking information that is in relation to you. You may want to treat it as confidential. Please let us know if you have any objections. So taking the third party into confidence is one of the primary responsibilities of the public information officer, right? And kindly note, the third party should be given an opportunity of representation if the PIO considers it necessary. And don't forget the fact that if third party information is disclosed without giving him a notice or receiving objections from him, the third party may go in and appeal. He may go to the Information Commission, he can go to the First Appellate Authority. So a third party is an aggrieved party per se, and hence the process and the procedure when information of third party is sought is something that the PIO has to necessarily comply with, right? And so he has to determine the information sought is relating to a third party, and the process under Section 11 has to be completely followed by the public information officer. So I think these are some of the responsibilities of the duties I would want to say that are encapsulated briefly in terms of the points so that we know what exactly the PIO must do under the Right to Information Act. Now let's take some of the sections under the RTI Act to discuss briefly what is the role and responsibility of the PIOs. Now, before we go forward and look at the provisions of Section 5.4, Section 5.5, kindly note these 12 duties that I had just mentioned. If there is a breach of those duties by the PIO, right? So the public information officer is supposed to perform these duties. Like, we discussed the duties of the public authorities. Now we are discussing the duties of the public information officer. So when the law imposes a duty, and if there is a breach of the same, the law generally prescribes a sanction, and the sanction under the Right to Information Act is prescribed under Section 20. And hence, in this case by R.K. Jain versus Union of India, a case decided by Delhi High Court in 2018, the court very clearly said that the law expects the PIO to perform his duties responsibly, and it is his responsibility to ensure that the information sought is provided for within the stipulated time, and he should be assisted by other officers. That is inevitable. However, you will notice that if the PIO fails in his duties, obviously there could be an attraction of the penalty provision, right? So very often than not, PIO suffers sanction and liability for the failure of his duty, and hence you will notice that the PIO plays a very important role vis-a-vis the ensuring or performance of his duties to that of the effect of any liability or penalty that could be imposed upon him. And kindly note, the courts have consistently held that if the public information officer has committed a breach of his duty, then imposing penalty unfortunately becomes mandatory. So the public information officer may not probably escape from the penalty provision as well. So the duty is a strict one. There are probably very less exceptions to escape from the same, and it is probably inevitable for the PIO to go about performing his obligations under the Right to Information Act. Now, coming to Section 5.4, Section 5.4 I think is a very important section according to what I feel in terms of the internal office management that has to be taken care of the public within the public authority. Now, what does Section 5.4 say? 5.4 says that PIOs may seek the assistance of any other officer, be it senior or junior, if he considers it's necessary for the proper discharge of his or her duties. Now, there have been so many instances where the public information officers have not received cooperation from their colleagues in the implementation of the RTI Act. Please note, one, to receive cooperation is so very important, but that cooperation also has to be in a time-bound manner because the information has to be given within 30 days. So it's not cooperation at the sweet will and discretion of the officer concerned. So while the PIO is a designated officer, he is not the sole and whole responsible person to discharge the functions to fulfill the mandate under the Right to Information Act. And hence, if any other officer fails to give assistance, I think the public information officer will be an aggrieved individual under Section 5.4. Correct. So that is what the statute's main purpose is. Now, generally speaking, any PIO would want to have assistance because the number of applications may increase, the number of information pages may increase, the communications may sink. This can become a full-time job at one point of time for the PIO, and hence every other person who is around him. Either, when I say around him, I mean either vertically or horizontally, either in the hierarchy structure or in the structure otherwise that we talk about it. The PIO needs assistance. We all know, one, that government offices are very complicated in nature. They are complex in terms of the structure and the processes that are in place. The worst of all is the record management systems. Right, they are very poorly kept, and the records are also poorly maintained, and hence all of these cannot be done by the PIO without he getting the assistance of people around him. Right, so the PIO can invoke the statutory law and seek the assistance of any other officer, and it is the duty of those officers to provide the said assistance to the PIO under Section 5. Now, this is where the most dynamic and interesting provision comes, Section 5.5. Now, generally, in government organizations, if you seek the assistance of any other officer, you expect that it will come to you. Right? So, first is to request assistance, cajole the same, and seek cooperation. However, in most organizations, this may not come by. So, there are those difficulties where cooperation is not received at all. So then what happens? What should be done in those circumstances? I think comes the next important section in the internal office management structure is section 5. Now, let me read section 5.5. It says, any officer whose assistance has been sought under section 5.4. Kindly note. So, in 5.4, I have sought the assistance and that officer is supposed to give. We think he will give, but there are chances that they may not give. Now, section 5.5 says, shall render all assistance. So, if your assistance is sought, you have no option. You have to render, right? As the case may be. However, in case there is any contravention by such other officer, please note, that means if that such other officer does not give assistance as sought by the PIO, then in those circumstances, that officer who has failed to render assistance shall be treated as a PIO. This is exactly the process of what is known as a deemed PIO. So I am the actual PIO, I have sought your assistance for the implementation of the RTI Act, you refuse to give it to me, you refuse to cooperate, you refuse to assist, then in those circumstances, you shall be considered as the deemed public information officer. Now, one will assume, what does this do? What does this deemed PIO actually mean? The deemed PIO actually means that in case tomorrow for the contraventions of the duties of the public information officer, I told you there are 12 duties that I have listed. If there is any contravention or breach of the duties of the PIO, say the most classic example of not providing the information within the time frame, then generally the penalty will be imposed on the PIO, correct? However, in this case, because the other officer has not provided assistance in a time-bound manner, and that is the cause of the delay in providing the information, that other officer will be treated as a PIO and deemed PIO will be summoned by the Information Commission. The deemed PIO will have to justify why there is a delay. And finally, if he is not able to adequately justify, the penalty under section 20 will not be imposed on the designated PIO. The penalty will be imposed on the deemed PIO. Right? So this is where the designated public information officer can, simply wash his hands off and say, look, it's not my whole and sole responsibility in implementing the RTI Act. I think the responsibility is to be shared by all other officers whose assistance has been sought. And if one delinquent officer has not given that kind of an assistance, he shall be held responsible. He shall be designated as a deemed PIO, and the penalty should be imposed on him and not me. So the public information officer can clearly be off the sanction and the liability for the breach of the duties under the RTI Act, and the breach of the duties shall be squarely fixed on this person or the deemed PIO. So I think section 5.4 and 5.5 are very critical, very important. Now, what does these two sections do? They very clearly say that a PIO cannot give excuses saying that he did not get the cooperation of other colleagues. That's point number one. Generally PIOs tend to shift the accountability, saying that, look, I asked his assistance, he did not give it. Right? So, very clearly, whoever has been asked the assistance must be provided, otherwise the penalty is squarely going to be imposed upon him. So, that is how probably the provisions of the law have been clearly designed, and they empower the PIO. Please note, that's interesting, isn't it? So, one who has been designated the PIO gets the right to seek the assistance, and it is the duty of those officers to actually do the same. So, I think it's an all-empowering section, it's an all-facilitating section, and the obligations are very clearly fixed, and hence you must note by reading section 5.4 and section 5.5 that the penalty under section 20 of the RTI Act shall not be only imposed on the public information officer, it can be imposed on any officer whose assistance was sought and who did not deliver, and due to whose fault there has been a denial of the right to information. That's the most important part that gets reflected by reading section 5.4 and section. Now, before we just go forward, I just have a word of caution. The word of caution is that section 5.4 and section 5.5 do not necessarily abdicate the role of the PIO, do not reduce the role of the PIO. I think the courts have made it abundantly clear that the primary role is always of the PIO. So he cannot shift this by making people as deemed PIO. This is not possible, right? So you are primarily responsible for providing the information. However, if there is fault that can be fixed on somebody else, then only. So the designated PIO cannot abdicate his responsibility, cannot shift his responsibility, cannot run away from the same responsibility, right? The provisions of the law are delivered in a goodwill manner to empower the PIO. It is a manner to actually strengthen the role of the PIO and to strengthen the RTI regime completely and absolutely. And hence, I don't think by the use of Section 5.4 and 5.5, the PIO should run away or shrink his positions and responsibility and just act like somebody who is a kind of a forwarding authority. So I think there is a caution that the courts have said very clearly that they don't expect the provisions of Section 5.4 and 5.5 to be used as somebody with some forwarding authority example, right? So you just cannot do that, and rather the misuse of 5.5 is something that the courts wanted to stop from, and hence they have cautioned the PIOs from misusing the provisions of Section 5.5 as well. Again, let's come to the role of an APIO. To reiterate, the Assistant Public Information Officer plays also a very important role. There is again no qualification prescribed about who can be an APIO, but the role of the APIO is assist the PIO, right? Now, one of the fundamental questions that has often been asked is, can an APIO independently process an RTI application? Can he give information directly? The answer to that is in negative. An APIO is there only to assist a PIO. So he can receive the application, give the acknowledgement, he can help the PIO in providing the said information, preparing the replies, so on and so forth. But an APIO cannot act independently. He cannot provide the information without any delegation of authority from the PIO. If there is specific delegation of authority on from the PIO, he can go about doing the same. Otherwise, an APIO is purely there only to assist a PIO and nothing more than that. No prescribed qualification for an APIO. However, the liability of the APIO is like any other officer. So, if the assistance of APIO is sought under 5.4 and he does not give it, then under 5.5 as a deemed public information officer, he is not deemed. Actually, he is a designated role. He is an assistant designated PIO. Then in those circumstances, a penalty can be imposed on APIO as well, right? So in this case of Muttaya versus PMO, it's a case decided by the Central Information Commission in 2007. The question was, can the government designate postmasters? The post office is a very small unit. It's like a small place where people go and take a lot of services, isn't it? So those places, very small, maybe it has some 10 or 15 people maximum or less than that. Sometimes in a rural area, the postmaster may be the single person who is dealing with it. So, can the postmaster be designated as a APIO under the Right to Information Act? The commission said, why not? Right? So, there is no qualification, there is no prescription about who should be a PIO, who should be an APIO. I think it is up to the government to designate any person, be it a postmaster or be it a postman, as a APIO. So, that's the freedom that the law provides for. Now, let's move to the application process. So far, we have discussed the responsibilities of the Public Information Officer and the Assistant Public Information Officer. We have looked at Section 5.4 and Section 5.5. However, let us look how the application is processed within a public authority. Now, the PIO may take the following actions on an application, right? Among them are possible three things. Just to get you clarity on how an application is processed within an organization. The first thing is that the application can be accepted, right? And the information is provided, right? Second action that he takes is that application is accepted and a decision is taken and communicated to the citizen saying that sorry, we cannot provide the information because it's an exempted information, and hence the application for information is rejected. That's a second action. The third action is the obvious action, as I told you earlier, that the PIO comes to know that the information sought does not pertain to his organization, it pertains to another organization, And hence what he does is, he cannot reject. Kindly note, that's the most important. He will have to transfer that application to the concerned designated public authority. So these are the three actions that a public information officer ought to take when an application is received in his organization. Let's move to Section 6. Section 6 of the Right to Information Act provides in Section 6.1 that a person who desires to obtain an information under this Act shall make a request in writing or through electronic means, right? In English or in Hindi or in the official language of that area in which the application is being made, accompanying by such fees as may be prescribed by the law. Now the PIO, as the case may be, has to be approached, and he is the person who is designated to receive this application when it is made by the citizen. So how can I make the application? I can make it in writing or I can send it electronically. What is the language? It can be in English, Hindi or in the local language, right? So these are three ways in which the application can actually be made to the public information officer. What should the application contain? The application should contain certain details: who the applicant is, what is the information sought, and what is the address to which the communication has to be made. These are certain basic information that should exist in the application, right? If the applicant requires any assistance, obviously he can seek the same from the PIO, and it should be the duty of the PIO to provide the assistance in making the application or in writing the application. You will notice that certain public authorities have designed a format for filing the RTI application. And during some early stages, they insisted that the application should be in that format only. And they justified why they require the format, because there can be some kind of uniformity in the application so that, record management is easier. But the CIC has consistently held that, yes, you can have a format, but you cannot insist on the application being only in that format. Right? The format is good, but you can't insist. So just because the application is not in that format, you cannot reject the application, is what the CIC has very clearly stipulated. Have a format. If people know that there is a format and they file it in that format, accept it. People do not know, then a plainly written application should also be accepted and processed, is what has been communicated by the Central Information Commission from time to time. Now, you will also notice that, the official language of a given area is depending upon which state are you filing that RTI application. Now, please know, if it's in relation to central government organizations, even in the state of Karnataka, the applications are usually made in English and Hindi, but can they be made in Kannada? Yes, they should be, and the central government organization should have a translator. They may provide the information only in English and Hindi. They are not going to translate the information into Kannada and give it to you. The application can be made in Kannada, is what is something that we can infer from reading section 6.1. So, 3 questions you can answer immediately from the discussion that I have. First, is there a format for an RTI application? Quickly, I think you can just answer this on your own. What should be the language for an RTI application? That's the second question that you would want to just answer on your own. And third, can an RTI be filed electronically? What do you think? So, okay, fine. After you answer these 3 questions, let's go forward, right? Now, very important is this case of Rajendra Prasad versus Directorate of Health Services, NCT, Delhi. A case decided by CIC in 2008. Now, this case very clearly states that, look, when an application is made by a citizen, he cannot amend that application at a later point of time, right? So, what he is seeking as information, he should stick on till the appeal process is completed. So, you cannot change that I actually wanted this information, so I will want to amend that RTI application. So, one application, whatever is stated as in the application continues to be the subject matter of adjudication till it is decided by even the High Court or the Supreme Court. If you require some additional information, you have to file a fresh application. So, please know, citizens do not have a right to amend their application, and the PIO is not supposed to go beyond what is there in the application. Generally, what happens is citizens orally make some requests, they orally want to make some additional changes. This is something that citizens often resort to. But I think the Information Commission has very clearly said that except what is there in writing, the PIO is not supposed to go beyond what is there in the application. I think, PIOs generally get into some kind of conversations with the citizen, want to get clarification, especially when the application is vague, there is no certainty. I think they go about seeking clarification so that they facilitate the right to information. People are not very expressive and clear when they ask sometimes. So there is nothing wrong if the PIO communicates and finds out what exactly is required by the citizen. Right? So if he's sure of what is exactly required by the citizen, then he can provide the said information. So I think that role and responsibility the PIO can definitely make while looking at the right to information. Let's move to section 6.2. And when we move to section 6.2 of the Right to Information Act, you will notice that an applicant making request for information shall not be required to give any reason for requesting the information or any other personal detail except those that may be necessary for contacting him. Now, I think section 6.2 is the most interesting section here. Why is it so very interesting? Because it very clearly says that a citizen need not justify why he is seeking the information. Section 6.2 very clearly empowers applicants and citizens to say that I need this information. Why I need it, I need not explain. What will I do with it, I need not say. Right? So section 6.2 very clearly says that an applicant making a request for information need not give any reason. Right? So, are you an aggrieved individual? Are you a victim? How is this information concerning you? No, you don't have to provide for them. Right? So, I think it very clearly states that information can be asked as a matter of right rather than as a matter of grievance or anything else. So, very clearly, citizens will say, I would need information A, B, and C. Right? Now, very often than not, public information officers are always very curious. They are curious about two facts. First, who is the applicant? Second, why is he seeking this information? 3, what will he do with this information? Now, for all these 3 questions, you will clearly notice that section 6.2 says this is something that will never be made available. Right? Why I am seeking this information? Because I am a public spirited individual. I want to keep a watch on the organization. I want to, gain more knowledge. I want to report it in the press. I want to probably use it in my research. There could be several purposes. Nobody needs to say or state those purposes. Now, I think section 6.2 is so important because remember, if section 6.2 was not there in the RTI, let me tell you very clearly, if it was not there, and that's why I feel it's the heart and soul of this legislation. If it was not there, and just imagine that the public information officer can ask for reasons. Why are you seeking this information? If that power was given to the PIO, then every PIO would ask, why are you seeking this information? And if the citizen gives a justification, the PIO will think that justification is not right to provide the exact information. Right? So he will sit in judgment on the reason for seeking the information. And unless he is convinced that the reason is adequate, appropriate, justified, he will not provide the information at all. And hence that kind of a role on the PIO is completely taken off. And I think the burden on the citizen is also taken off in giving justifications. So it's not only victims, it is not only an aggrieved person, it is not only an injured individual who has the right to information. I think every person, irrespective of whether you are a victim, whether you are affected, whether you are aggrieved, you have the right to information. Right? You may ask the information just for fun. That's also okay. But please note, you should also be cautious that you don't misuse the right. You don't abuse the right that is being provided. So you must use it in a very cautious, responsible manner. And I think section 6.2 is very, very important. It means also the fact that if I recollect in the previous module I told you that the principal rule of locus standi, why are you before us? Right? That is what is something that the courts will ask. So suppose you file a writ petition in the High Court or the Supreme Court, you have to justify why you are before the court of law. Right? The exception to the locus standi principle is the public interest litigation concept. Right? Now here again you should notice that the locus standi principle is not there. Why are you seeking this information? It's definitely not there. So you are seeking the information in public interest or public cause. What will you do with it, I think, is not the business of the public information officer, is not the business of the public authority. However, kindly note, section 6.2 is the rule. You don't have to give reasons. But the exception is that sometimes a citizen may seek information that is exempted under section 8. Right? You know you're seeking exempted information. So you're a well-informed RTI applicant. So you know the information that you have sought is definitely not going to be provided because it's going to be exempted. However, under section 8, which we will come to a little while later, see, exempted information are not always exempted. The Right to Information Act is so beautifully designed that some of the exempted information may be provided if there is a larger public interest that can be proved or justified. Take the example of information that is confidential or private. These are exempted information. But the section very clearly states that the said information can be provided if there is a larger public interest than protected interest. So there is a test. There is a kind of a justification that can be made. Now, the citizen in his application can give reasons for seeking an exempted information. The citizen can justify why he is seeking that exempted information. He may explain why he is seeking that exempted information. And through his justification and explanation, if one comes to know that yes, there is a larger public interest, then it will help the PIO to make a decision in disclosing the said information. Right? That's the only basis on which the PIO can decide. So if he thinks the reasons and the justifications are strong enough, he will favor disclosure. If the reasons and justifications are not strong enough, he will favor rejecting that application. So while section 6.2 says reasons need not be provided, that's the rule. However, reasons have to be provided if a citizen is seeking an exempted information. It is the duty of the citizen to make the justification. It is the duty of the citizen to justify larger public interest. If he does not, then the PIO has the every right to reject it. So the PIO is not going to sit and make his own judgment about disclosing exempted information. Rather, he has no business or no role to play there, whether it is in larger public interest or not. It is a citizen who has to justify the same. And if those explanations, justifications are good enough for the PIO to make a decision, he would definitely go about and make that decision as well. So that is where I think very clearly section 6.2 becomes the most integral part of the right to information. Section 6.3, as I told you earlier, is the transfer part. Right? So section 6.3 says if an applicant or an application is misdirected, well, this can very well happen because there is so much less information with citizens. They are not sure which public authority has what information. So what they do is sometimes they combine the required information into one application. So these are possibilities. So there is a foreseeability of the chances of misdirected, informed citizens filing RTI application. In those circumstances, please note the PIO cannot reject. And section 6.3 says if the subject matter in the application, please note, one pertains to the concerned public authority and the other that pertains is also closely connected. So it should not be randomly two different questions that are asked or information that are asked under the RTI. Right? But they're closely connected and the PIO thinks that one belongs to me. The other, yes, it belongs to one of our sister organizations, but not mine. Closely connected with the functions of another public authority, then the application shall be transferred to that concerned public authority by whom? Not by the citizen, by the public information officer himself. So this is where the transfer power under section 6.3 has to be exercised by the public information officer. Right? So once he does this under section 6.3, he has to notify it to the citizen. So he should tell the citizen what action has he taken under the application, isn't it? So the citizen has the right to be informed, saying that look, point number 1 I am going to be, point number 2 I have transferred it to my sister organization. I can give you an example regarding the same. See, suppose I apply for information from say Karnataka State Road Transport Corporation. Right? Now the Karnataka State Road Transport Corporation runs intercity buses. Right? Whereas the intra-city within the city is run by BMTC, that is Bangalore Metropolitan Transport Corporation. Now, if in my said application I seek information about KSRTC as well as BMTC, now the public information officer to whom the application first is being made, the PIO in KSRTC, will process the information that he has or his organization can provide. Whereas for the second information on BMTC, he'll have to exercise section 6.3, because BMTC has a separate wing function officer public authority. So he will transfer it under section 6.3 and he'll tell the citizen, look, regarding BMTC, I have transferred it to the concerned PIO. You will receive BMTC information from that PIO. Whereas KSRTC information is something that happens. However, kindly note, any such decision to transfer an application under section 6.3 has to be made within the first 5 days of receiving that application. He cannot take his own sweet time to transfer this application. So the PIO must read the application very, very carefully. It is his duty to provide his concerned information within 30 days. It is his duty to evaluate whether the information sought is closely connected with another public authority. And if it is such, within the first 5 days, he must transfer that application to the second public authority under section 6.3. Right? Now, that second public authority will get another 30 days from the time it has received that request to provide the said information. But the time frame for transfer of application is just merely 5 days. Okay? Within the first 5 days, that transfer has to be made by the public information officer. Now, the responsibility after transfer is also very important. Most public information officers think that after they have exercised the responsibility to transfer, their responsibility is over and they don't have to do anything regarding what has been given or access to the citizen. So they sometimes fail to communicate to the citizen, fail to keep the citizen updated with what is happening with that transfer application. And hence in Arvind Kejriwal versus DOPT, Government of India, the Central Information Commission very clearly said that if an RTI application is transferred to the actual custodian of the records, right? If it is done so, and the powers under section 6.3 is used by the PIO, it does not mean that the PIO's role has ended. It is still the responsibility of the PIO to see that the citizen finally gets the information, or it is the responsibility of the PIO to see that finally the communication reaches the citizen. So the citizen must be well informed. The citizen must be kept updated with, and the PIO continues to hold the responsibility for section 6.3 transfer applications as well. Right? So that is again a very important judgment that comes from the PIO in terms of the role and responsibility of the public information officer. Now, section 6.3, like any other power, has also been misused. Now, if you look at this case called Girish Mittal versus Ministry of Railways, decided by the Delhi High Court in 2014, this was a classic case where there was a misuse of the transfer power. What happened in this case was there were a 15-point request for information that was sought from the railway board by an applicant. And all this information was regarding the train called Garib Rath in all zones of the Indian Railways. So this Garib Rath was just introduced and it was running in many places. Now the PIO and the Ministry of Railways, thought that the best thing to do is to use section 6.3 and transfer it to all the divisions and zones. Right? So he thought he was just a forwarding authority, and the best thing is to do is to use 6.3, forward it to all the divisions, and they will provide the said information. Right? Now, in this case, the court came down heavily on the PIO, and they said that he had misused the power under section 6.3, and there was a malified intent. Because what happened in this case was that the PIO even did not apply his mind. He did not even consider whether this information was already there in the ministry level before transferring it to the zonal or the divisional level. And he randomly kept on using section 6.3, and so the court said, please note, PIO is not a forwarding authority. He is not to use section 6.3 and abdicate his role under the Right to Information Act. And he should have arranged for the information. He should have been far more helpful in giving the said information. And in this case, misuse is quite clear. and what has been used here is not in consonance with the spirit of the Right to Information Act, is what was decided in this case. So there is a caution against the use of Section 6.3. When should it be used? How often should it be used? What is the intention for the use of the same is something that has to be often looked into before the PIO can exercise the powers under Section 6.3.